Hi and good afternoon, madam. So today we are going to present principle of law, contract and tort. This is my group mate, Nur Rania, Kowehan, Fauzan, and I'm Ezra Nurwi.
The task question we are got is the task 2. The log plan station SDN DSB called for the tekan masuk for fertilization process. This company uses fertilization technical from water and fluid procedures. This operation is scheduled every 2 weeks. A year later, a new housing area and bus depot was owned by Nabu Transportation SDN DHD, where deployed inside the family. The fertilization operations was held as scheduled. Few withdrawals of fertilizer for vessels which were scheduled for operations on that day. The business were very dirty and smell bad for 5 hours. Therefore, Nabu Transportation SDN DHD must rate other business to replace the dirty buses. At the same time, the noise from the fertilization operation is disrupting adding sleep who works the night shift as he lives near the farm. Discuss the legal actions between log plantations SDN DHD and Naval Transportation SDN DHD and the law plane station.
Next, so to solve the situation before this, we need to use the ideal solutions. I is for issue, and the issue is whether the Naval Transportation Sdn Bhd can take a legal action to Telok Plantation Sdn Bhd under the terms of reason for bringing a damage to the bus. For second, whether ADEM can take a legal action against Telok Plantation Sdn Bhd for nuisance because of the noise from the fertilization operation is disturbing his sleep.
Okay, next, D stands for definition. Nuisance is a common law tort. Cause of offense, annoyance, trouble or injury, describing as an activity, condition that is harmful and annoying to others. Other word is that a non-stop, unlawful and circular hindrance with a person's enjoyment of the land. Based on the unreasonableness of the Defendant's Act and its enterprise more on foreign settlement rather than compensation.
Next, E stands for elaboration. There are 2 types of nuisance, public nuisance and private nuisance. For public nuisance is an unreasonable interference that materially affects the reasonable comfort and convenience of the public's right to property. Next, public nuisance interferes with public health, safety, peace or convenience. Cause harm to the public and environment, and it's not a requirement that the nuisance act must affect the entire or every single member of the society. Last but not least, for public nuisance point is an unreasonableness may be evidenced by statute or by the nature of the act, including how long and how bad the effects of the activity may be. For the private nuisance point, private nuisance is the action on the case and protects a person's right to the use and enjoyment of their land. Next is an unlawful hindrance to a person's use or enjoyment of land and property. Last but not least, private nuisance is an interference conducted to the right of specific person or entity between neighbors, with one property owner being negatively affected by the acts of the neighbors.
Applications: Suzuki vs Monroe. Facts: Mr. and Miss Monroe has installed an air conditioner outside Mr. and Miss Suzuki's bedroom window and installed a sensor camera overlooking the neighbor's house. A noise arose from the air conditioning plaintiffs were not unduly sensitive and the noise from the air conditioner interfered with their sleep. Tort held the affected neighbors, Mr. and Miss Suzuki, were aware total of 6,000 in damage. For instance, in addictions, Mr. and Miss Morrill for depends to operator their air conditioner if it costs long 55 feet from 7 a.m. to 10 a.m. and 5 dB overnight.
So this is the next case which is happened in Malaysia, and the case is Wisma Punca Emas Sdn Bhd versus Dr. Ronald R.O. Holohan, 1987. Wisma Punca Emas is the plaintiff and Dr. Ronald R.O. Holohan is the defendant. So the facts for the case is, the case against the appellant was summed up in the statement of claim as follows. The indiscriminate excavation and removal of earth, stone and clay from the defendant's property without ensuring sufficient support for the adjoining properties and without taking sufficient precautions and providing adequate support or otherwise has 1987 1 ml J 393 and 394C caused the surrounding areas to be lowered, thereby causing the said premise of the plaintiff to sink and it was to move from its original position and the premise has been damaged. So for the court held in this case, appellant's counsel for the respondent said that the cause of action is founded on the natural right of support. That in the context of the present case is the same as saying that the claim is based on nuisance. In any event, it is clear that the appellant was not caught by surprise and his defense was in answer to what was alleged in the statement of claim. There was no conceivable prejudice that the word nuisance had not been expressly set out in the statement of claim.
The next case is Specific Engineering Ltd versus Haji Ahmad Rice Mill Ltd on 1966. The facts is that the plaintiff brought an action for an injunction to restrain the defendants from burning rice husk in the compound of their premises and bringing or permitting to remain on their premises rice husk to such quantity and in such manner as to cause a danger from the fire to the plaintiff's premises and dumping or permitting to be dumped on their premises rice husk in such manner that by being carried by the wind or otherwise to the plaintiff's premises they cause injury to the plaintiff's property or the employee, invitees and servants. So for the court held is, the plaintiffs have produced ample evidence to show injury to property and interference with personal comfort caused by the smoke, ashes, dust and rice husk which emanate from the defendant's premises and that this constitutes a nuisance in law. Also the plaintiffs were entitled to damage and injunction against the defendants.
In conclusion, based on the case Labu Transportation Sdn Bhd versus Teluk Plantation Sdn Bhd, Labu Transportation Sdn Bhd can't take any legal action towards Teluk Plantation Sdn Bhd. This is because the cost of the fertilizer fell onto the past is an action founded on natural right of support where it happened by an impactful of wind weather. So the incident that happened was not intentionally by Teluk Plantation Sdn Bhd. Based on the next, this one, based on Adeng versus Teluk Plantation Sdn Bhd, Adeng can't take any legal action against Teluk Plantation Sdn Bhd. This is because the fertilization operation by Teluk Plantation Sdn Bhd already scheduled that they help it every 2 weeks. Besides, the farm has been operated before the plantation inhabit the area.
So that's all from us.